Today was the second and final day of the hearing against prorogation here in Ottawa in federal court, and I think that the applicants did a pretty good job of trying to prove to Chief Justice Crampton why Crampton should issue some sort of a remedy for this situation. The situation, of course, being that every Canadian in this country does not have any representation in our government right now, and Mr. Manson made the argument that having a representation in the right to vote isn't just casting your ballot, but is actually having the person you voted for representing you in government, in the House of Commons, doing committee, doing question period. And that's not something that we have in Canada right now. The main piece of legislation that the applicants brought forward to support their motion is the Miller 2 case from the United Kingdom, where the Supreme Court of the United Kingdom decided that Prime Minister Boris Johnson's decision to prorogue Parliament was both unlawful and that prorogation itself could be subject to being reviewed by the judicial branch, that it's under the prerogative, that it's the ability of the court to review prorogation. So that was a landmark and controversial decision, but apparently was unanimous in the Supreme Court of the United Kingdom. And that's the legislation that's being brought forward here under something called persuasive authorities to be considered by the court in making a decision on this matter. And a persuasive authority is an authority, a citation that is not binding. The court does not have to follow it, but they can use it to inform their decision. And cases from the United Kingdom can be used in this way because being of the common law as we are, and a lot of their laws are based on, our laws are based on their laws, not their laws based on our laws. I think, again, that the applicants did a good job, but there are parts where I could tell that the Chief Justice Wagner of the federal court was not maybe entirely convinced of the argument being made, or maybe he was asking for more than the applicants were giving him. But let's start where I began halfway through the day. I didn't even know I was coming to this because I worked all yesterday, so I didn't know I was going to be here. I didn't plan to be here. There was great coverage from Northern Perspective and Amazing Zoltan on X and on YouTube for Northern Perspective, and on the other sites that Mr. Zoltan is on for his coverage. But they have a wide breadth of coverage on this. So I'm coming into this late and kind of blind. I wasn't here for day one. I wasn't here for most of the morning. And I came into the government lawyer saying that there is no grounds for this, basically, that the Miller test can't be applied, and even if the Miller test is applied, that it doesn't, according to the Miller test, the Miller case, there's nothing to move forward with here. Now, in Miller, there's a three-part test. The first part is that Parliament is frustrated, and I missed the second part of the test, but the third part is that the consequences are dire enough to need an action. And there was a lot of back and forth on the word frustrated, and the Chief Justice at some parts would say, well, maybe it's the frustration, the use of that word is the problem. Don't we have something like that in Canadian law? And the government's like, no, you can't just pick and choose what you want. Well, that's kind of what they do all the time, the government. They seem to love to have their cake and eat it too, and pick and choose and bring it all about. Like, for example, I believe there was an argument that happened where the government provided scholarly arguments, because this is a big topic. This is a very zoomed out topic where it's not something that's been through the courts a lot. So in this particular instance, the government, I guess, solicited or was provided scholarly opinions on this, and they tendered those. And I believe from my read that the applicants did not approve the way that the scholarly articles were tendered in court, that they should have been expert witnesses instead of just nonchalantly cited. I don't know if I got that part right, but in these scholarly arguments being cited as sort of an authority for what to do here, and like the Chief Justice said, there's scholarly opinions on all sides of this issue. Can't really depend on it, but that's an example of the government providing something in a way that may not be 100% correct, and also something that's just kind of out of left field to try to get to the result that they want, which is the dismissal of this application. And they also are seeking costs. So that was the last thing. There was 3 government lawyers that I heard from, each one kind of addressing a different area. One was the remedy, no remedy would be appropriate, and the remedy that is being sought is political, and that it would not be right for the court to issue that. And then the final person closed with, the government wants the application dismissed and we're seeking costs. So that's just the cherry on top of all of it. And the arguments the government is bringing are all over the place, and they don't make a lot of sense, right? Like, the government is saying that the Parliament is not frustrated, according to the tests in Miller, because eventually Parliament will come back. So they will be politically accountable at a time in the future when Parliament comes back, and they're trying to argue that prorogation, the political foundation of prorogation, is legal, and it was done according to the only limits that exist on it in Section 5 of the Charter of Rights and Freedoms in the Canadian Constitution, and that says that Parliament must meet once every year, and that no Parliament can last longer than 5 years. So as long as you're doing that, I guess prorogation is legal. So you could prorogue for an entire year just to come back for 1 day a year for 5 years, and that's totally legal according to the logic in the government's argument here, which is just totally nonsensical. So that's part of the argument the government is making. The government is also saying that no, the applicants don't have standing. The two applicants who are being represented, I believe, by or the council is being funded by the JCCF, the Justice Center for Constitutional Freedom, and that they don't have standing, public or direct standing, public interest or private standing on this matter. So that's going to be a new point of contention for the Chief Justice to consider in any decision that he makes. And I guess the applicant's response to that was that they do have standing because they're they're prejudiced by the decision of the Prime Minister to not follow the proper conventions in prorogation. That's another big argument that was happening, is that prorogation is not written in law, therefore it shouldn't be subjected to courts. It's like, what are you talking about? It's like it's a legal convention and a constitutional convention, and it's happened in kind of unwritten ways, and it should continue that way. And then we'll talk a little bit about one of the interveners that I think was intervening on behalf of the government, the wild things that they were saying, like government arguments. Miller doesn't apply, so we can't cite that, and if it does, there is no frustration to Parliament because Parliament will come back at some point in the future, and it's not like there was any bill on the table. Basically, even the Chief Justice seemed to be adopting that at some point. He's like, well, if this was later on, well, if there was a bill on the table, for a non-confidence vote in progress or something, it might be a different conversation. It's kind of a gist of what he was saying at one point, I believe, but it's so silly. So prorogation. The argument that the Chief Justice was really trying to ask at the end to Mr. Manson was, how can I design this? And so if I were to issue a ruling in your favor, what can I say in the ruling that would make it so that people can't just come to the court anytime there's a prorogation in the future that they don't like? Like, how do I make the test? Well, my answer to that would be, and Mr. Manson said, well, look at Miller. Are they having those frivolous cases in Miller now that the UK Supreme Court has made that decision? But my answer would be, the court's job is to investigate and to hear these challenges to the situations that arise. Their job, the reason they have a paycheck, is to evaluate these circumstances and make decisions accordingly. That's why they exist, as a check and balance. There was arguments against checks and balance, saying that the executive is overly infringing upon the ability of the legislator, and then the government was arguing, well, no, actually the executive could do whatever they want. They can influence the legislator in huge ways. They can dictate the mandate of the session. They can choose which days the opposition has opposition day motions to bring forward stuff. And so I guess that means that they can't be infringing on the legislator because they have those select abilities. Like, so the arguments, if you follow them to their conclusions, their logical conclusions, they don't make sense. None of it does. And the bottom line of this all is that we Canadians right now don't have political representation. We don't have a power in our legislator right now to say that to have a voice in our democracy, and that's not okay. And the court seems really hesitant to get involved here, and they want really clear guidance from the applicants on, okay, what can be the constraints of this? And the applicants are saying, well, look at Miller, look at what's happening there. And the government is trying to respond to that, saying, well, no, actually Miller doesn't apply. First of all, in Canada, we have the Constitution's way up high, it's insurmountable, and the Constitution applies the only two limits to prorogation. And whereas the applicants are coming back and saying, well, if you look at convention and how things are supposed to be applied, there's a whole bunch of ways that this is supposed to happen. This is not what's happening here. And then the applicants go on to say that our clients the applicants are prejudiced by the fact that the fact is that the Prime Minister has an obligation to exercise prorogation in accordance to the line and objects of the convention of prorogation, and that he hasn't done that. But by having that obligation, he inherently creates a right for others to have him follow the order and the line, basically the proper way of doing the convention of prorogation. And the fact is that if he hasn't, then those people have been prejudiced by his behavior, so there should be a remedy to that. That's the crux of this. Let's talk briefly about the intervener, the person who intervened, who came after the break. Was just wild. wild. They started off with the Canadian courts have been really great. This is this pompous behavior that we've talked about previously about how Canadians have this unearned sense of superiority over Americans. And in this particular instance, this person was saying that Canadian courts have acted really wisely to not have a Bush v. Gore moment. Okay, first of all, what does that have to do with anything we're talking about? And he went on about this for about 5 or 10 minutes, saying that the Supreme Court in the United States has never recovered their image from intervening in the Bush-Gore election, and that people were saying before 9/11 that Bush is not my president, Bush is the Supreme Court's president, and that the Supreme Court has caused injury to its reputation in the United States by doing this. It's like, what does this have to do with us in Canada having a say in our democracy and having our elected representatives represent us in our parliament that Trudeau has prorogued for an excessive amount of times, not a trivial amount of time, till I think it was 77 days, so that they could have a leadership race while we do not have our voices in Parliament being heard. Like, what does that have anything to do with this? And he went on and on about this. He said people rallied around Bush after 9/11, and then he started talking about, he's like, well, the United States was at the time and nowhere close to X has made his ruling, now let him enforce it. So he's quoting Andrew Jackson now from the 1800s about something that has nothing. So he's going deeper and deeper, and then he's talking, he's got some TDS coming out about Trump. He's like, well, with the Trump situation, now they actually kind of are close to having someone say X made his decision, now let him enforce it. Us here in Canada, we're so smart, we've never done such a thing. It's pure stupidity every way you look at it. It really hurts to think about. And this guy's, at the end of the day, he said, well, the thrust of our submission is, he made a couple points, but they just went in circles. It seemed like he wasted a massive amount of time. And at the end of his submission, he was, I guess, an intervener again for on the government side. I think some sort of association with, never mind. But the thrust of our submission is that if the government, if the court sees Mr. Trudeau's advice as advice, then you can't do anything about it. So the applicants were arguing that Trudeau giving the advice to the Governor General to prorogue Parliament means that the result of that advice, the legal effect of that, is that Parliament is prorogued, and the source of that is himself. Because in this case, in prorogation, the Governor General cannot refuse the advice of the Prime Minister. And so that makes it effectively an action only of the Prime Minister, where the government was trying to argue that actually, no, first of all, there's no frustration here and there's no consequence. Miller, that would be the Miller case. But even if there was, blah, 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 no matter what, the government has the right to prorogue Parliament, and nonetheless, even if the government did make a mistake here, it's on the Governor General. So they're trying to pretend, the government is pretending that there's a check and balance in the Governor General, even though the Governor General in Canada hasn't refused the advice of a Canadian Prime Minister in at least 100 years. Okay, first of all, it is written into law. So they're trying to say, well, look at the Constitution of Canada written in the mid-1800s. It says that all executive power lies in the Queen and her descendants and the Governor General. That's your check and balance here. What? If like the applicants argued, if someone goes to the Governor General and says prorogue Parliament, the Governor General just prorogues Parliament. It's a rubber stamp, just like royal assent. And then that point was also made. Like in the case of royal assent, just because the Governor General gives a bill royal assent doesn't mean that the bill originated with the Governor General. It's just a part of the process, right? And it is effectively a rubber stamp. But I guess there was a specific case of case law. I think it's Conacher, something from 2009, I believe, Supreme Court of Canada. I think it had to do with dissolution. And then I might be getting my case law mixed up here. But anyways, there's a case with dissolution. The applicants argued, Mr. Manson, I believe specifically, saying that in the case of dissolution, there is discernment there. There is a specific word, I forget it, but there's input, right, from the Governor General on that. There's a discussion that can be had. Like, I guess there was an example of Stephen Harper and Michael Jean, right, the former Governor General, where she was able to have a discussion about the dissolution, and there's some input on that, right? Because I guess in the case of losing confidence or something, the government can go to the Governor General and say, well, I have the confidence of the House. Well, who has confidence of the House? Is it this person? Is it that person? Can we have the election here, there? But in the case of prorogation, there's absolutely no discernment. There's absolutely no discussion. It's an automatic rubber stamp. Let's do it. So therefore, the effect is proroguing Parliament, and the source is the Prime Minister, even though it's technically advice, right? The Governor General is a rubber stamp. Yes, the authority is with them, but the actual power, the invocation, it begins and ends with the Prime Minister. He says prorogue Parliament, the Governor General says how long for, right? That's it. So the Governor General, the Prime Minister, through their actions, is creating this, has an obligation to follow the line and object of proper prorogation procedure, and by not doing that, and that creates a right in people to have the Prime Minister doing that, the obligation, and in this case, the applicants were prejudiced by not having the Prime Minister follow the proper procedure for prorogation, by having it be excessively long, by having it be for very stupid reasons, not justified properly, like for the fact that they want to have a leadership race. Like, yes, there could be political prorogations, but to act like this is something that happens all the time, it's just not. We don't do 3-4 month prorogations, 77-day prorogations for leadership races. Like the applicant said, the leadership race could continue if Parliament is in session. The bottom line is we Canadians live in a democracy. We have a constitutional monarchy and a parliamentary democracy, and we have a right to be represented. And in the Section 3 of the Charter section that says that we have the right to, sorry, moving on to Section 3, but the Charter says we have a right to vote, and not just to vote, but to have our votes matter. When our vote elects someone, our elected representative is our voice in the House of Commons, and that means that they're our voice in government, in the procedures of the day. It's not just a vote one and you're done kind of thing and your rights are fulfilled. No, it's an ongoing obligation between you, the government, to you, in your representative, to represent you continuously, not just one day a year. Well, 364 other days is prorogued. So in my opinion, the correct outcome here is that the Chief Justice decides that prorogation was illegal, that there are limitations on prorogation, that even though the government is arguing it's a convention and not a law, therefore it can't be judicial, it can't be, there's a specific word for it, it can't be accountable to the judicial branch, and that it's not infringing on other branches because the executive gets to infringe on them anyways, and all these other arguments that they're bringing up, or the applicants don't have standing, and all these different arguments that they're making here, or that the Miller test isn't satisfied and that Miller doesn't apply because in Canada we have an utmost, a absolute constitution basically where it's not the same. And then they even tried to argue, well, Miller is totally different circumstances. There was the Brexit impending, there was a hard limit on implementing it, there was a referendum where the majority of the people voted for it, and then they had to implement it properly and all this and other stuff. We didn't have that here. But the case is that we all, for step 3 of the Miller, I just wanted to mention this, we do have consequences. We have the tariffs. We need our legislator in process, to be in session, so that people can hold, that our government can function, and the government can be held accountable by the legislator, not at some future date, months after the harm is done through the tariffs and the economic turbulence happening right now, but now. And that's what it is. Like, there are immediate and urgent consequences. Trump announced tariffs on steel. They're coming in March. And then we also know that there's going to be future tariffs on Canada specifically. So we need our legislator in session to deal with this immediately and to hold the government accountable and to be able to do things like non-confidence motions if it's relevant and necessary and applicable. So bottom line, I think the correct outcome here is that Chief Justice Crampton says that the government acted out of bounds, and that yes, there is a limit to this, and that they've broken it, and creates a test for this. And then he was really worried, Chief Justice Crampton, at the end, like I said at the beginning, going in circles with Mr. Manson about the prorogation and about, what do we do if people just keep coming with these frivolous claims? Well, create a test that weeds them out properly, and then, like Mr. Manson said, you can use costs to dissuade people from coming with frivolous matters. The whole purpose of the judicial branch is to be a check and balance on the other branches, and the Crown is not a check and balance. They haven't done anything against the advice of the government in 100 years, and if they did, everyone would call it rightfully a constitutional crisis, right? Because who was it? I think it was the government who said, well, we don't want to have unelected people, judges, telling the government what to do, right? But then, and he's like, well, the Justin Trudeau was elected, that gives him legitimacy, that gives him democratic legitimacy. Well, what would happen then? They're at the same breath arguing that and I believe it was them who made that argument, because it'd be really I think that was them. But then to say in the same breath that, well, it wouldn't be appropriate to have an unelected person telling an elected person what to do, but at the same time you want the governor, or you're saying the governor general is the hard check and balance on the prime minister's power, basically. But at the same time, if they ever did exercise that, it would be having an unelected person telling an elected person what to do. A lot of their arguments are contradictory. Again, they're the kings of the government, of having their cake and eating it too. Anyways, that's
the government trying to insert an unelected leader right now as well.
Yeah, so Mr. Chris Dacey with his famous closing line, trying to come in off the ropes as he usually does. He's over here.
Hey guys.
Yeah, so I'm sitting here while I finish this, but I came in late last. I didn't come in for the first day. Came in halfway through this day. I think that there's a real possibility of the Chief Justice Crampton ruling in favor of the applicants and saying that the government acted ultra vires beyond their legal capacity in doing this, but there's a real possibility they don't. We'll see what happens, and I'll tell you how it goes.
When do we get a decision?
Before it becomes too moot, said the judge.
Okay, that is.
But it's already becoming too moot because the tariffs are coming into play. So I think that a decision in the next week or two would be applicable to that timeline, or even as sooner than that.
So timely.
Yes. All right. Have a great day.